Live from the Glasgow Electric Plant Board, Glasgow Wants to Know. With your host, Mr. Uhel Barrickman.
Good evening. Tonight our subject is abuse of judges and lawyers. Now I know that many of you out there are probably saying, surely you jest. I don't. I am serious. The news media, as well as many of you citizens out there, are blaming lawyers and judges for the increase in crime, for anything that goes contrary to what you consider to be right, such as increase in insurance premiums, the cost of various products, claiming that the costs have increased because of products liability lawsuits and large judgments. To understand that the lawyers and the judges are not responsible for the things that many of you, and the news media in particular, ascribe to judges and lawyers, you have to go back to the origin of the judicial system and our legal system and the responsibilities of judges and lawyers, including what they ethically do. I have to help on this subject tonight the Honorable Willam Cooper, who is our Justice on the Supreme Court of Kentucky. He lives in Elizabethtown, and our own Circuit Judge, Benny Dickinson. I'm going to start with you, Judge Dickinson, and ask you what event happened on June the 15th, 1215 at Runnymede, England.
Well, because I was properly coached, I can tell you that the Magna Carta was signed at that time, and I knew that anyway, but I didn't know that it was June the 15th, 1215. I thought it was 1210 or 1212. And in any event, that the King of England, with that document, gave up certain rights that he had and prerogatives, and gave those up to the lords and noblemen who had confronted him there, gave them certain rights to be heard and to have their cases decided, and took some of the arbitrary power away from the king at that time.
Justice Cooper, what actually evolved down the years after that?
Well, I think we could say what actually evolved was the basis for what is now known as a Republican form of government, and the legislature were ultimately evolved from this charter. But primarily, from the point of view of a judge, the most important thing that evolved was our system of trial by jury.
Now, as a result of that charter, of course, eventually you had the institution of the English Parliament, but how did the law develop as a result of that charter?
Well, of course, the law in its early stages developed by what we call common law, in that judges would create or make the law as the fact situations were presented to them. And basically it was a question of what is fair. And this evolved over the years in England, and this is the primary point and primary type of legal system that was brought to the United States from England, and which has now evolved to the present day. Of course, parallel to the common law development is the development of statutory law, which are the laws that are created by our legislatures.
And insofar as the common law is concerned, it was brought from England to Virginia, as well as the other colonies, and then from Virginia to Kentucky. Now, how is the common law changed?
Well, it's changed by judicial decision, and it's been, I like to say that the judges don't change the law, the judges adjust the law to changes in society. Now, you may disagree with that, but that's the way that I observe the development of the common law. As the society changes its expectations, then the law tends to change. It comes along a few years after, you understand. But the law tends to change to meet society's expectations, is the way I view it.
But mainly the basic common law is changed by legislative enactments.
True. Of course, the legislature can change that law anytime it so chooses. Judges can also change the common law by creating new precedents. But either the existing precedents can be overruled either by the courts or by the legislature. And the judges cannot overrule the legislature unless the statute happens to violate the Constitution.
Now, we've just come upon and mentioned another basic foundation of the law, particularly in this country. And what's that, Judge Dickinson?
Constitution. And it's still today an amazing document that has lasted these over 200 years. That we have principles embodied in our Constitution that are the pride of this country and the envy of the rest of the world, that we make our basic law from. And there are certain things that the legislature cannot do. We have certain basic constitutional rights that are there no matter what. And the Bill of Rights has the first 10 of those. And it amazes me in court that there's so many people, everyday people, non-legal trained people, are conversant with constitutional rights. They know what their rights are, and they can articulate those rights. But the Constitution tells us what the basic law of the land is, and the enactments of the legislature have to abide by the Constitution. It can't be broader than the Constitution. The lawyers and the judges said that a long time ago. John Marshall said that, and the Supreme Court in the earliest days said that the court decided what was going to be constitutional and what was not going to be constitutional. So it's still a balancing act between the legislative branch and judicial branch about what the law of the land is.
Don't you think the Constitution can be viewed as setting the parameters within which the courts and the legislatures have to operate? In other words, the legislature has a lot of discretion on what it can do as far as enacting laws, but that discretion is set by the limits that we find in the Constitution.
Yes, sir. Now, as far as we're concerned, and by we I'm talking about the citizens here and the citizens of the Commonwealth of Kentucky, is the federal Constitution the only Constitution that controls us, or is there another Constitution?
No, we have two. There's one in Kentucky too. And a lot of the provisions in the Kentucky Constitution parallel those provisions in the United States Constitution. But when we're making decisions based on constitutions, we have to interpret sometimes. It doesn't come up very often in my court, obviously, but we have to interpret sometimes both the constitutions of the United States and the Constitution of Kentucky, even though most of their provisions are parallel. We have one strikingly similar to the U.S. Constitution.
If they are in conflict, which one prevails?
The big one. The U.S. Constitution. We can't pass laws here that violate the Constitution of the United States. That's the sovereign law.
Now, first of all, let's talk about the justices of the Supreme Court of the United States, as well as the justices of the court on which you sit. What are their functions, Justice Cooper?
Well, we take cases that are presented to us, and primarily they are appeals from trial courts. Now, Judge Dickinson is a trial judge, and I was the circuit court judge in Hardin County for almost 18 years. And the trial judges make the initial decisions with regards to the cases that are presented, and then the party who's dissatisfied with the result will then appeal to a higher court. And whether it's the United States Supreme Court or the Kentucky Supreme Court, and the function that we have is to review those cases, not to change the facts or to change the jury verdicts, but only to see if the law was properly followed, if it's a jury trial, whether evidence was properly admitted or excluded, whether statutes were properly adhered to, and primarily whether the Constitution was adhered to.
And basically, in most cases, you are merely interpreting, first of all, the Constitution or constitutional rights, if they are involved, or statutory rights, or rules of court, the common law. You're not making law, you're interpreting law. Is that not correct?
That's our function.
That's your function. Now,
we ought to point out too that when we speak of the common law, and people that are not trained in the law might not understand that, but common law is those kinds of cases that Justice Cooper is talking about, where his level of court would make a decision. Well, then I, on the lower level in the trial arena, I can read that decision, and I know what they have decided about that area of the law, so that I can follow that later on. And that's what the common law is all about, so that we have all these precedents that tell us what the Supreme Courts of the states in the United States have said about a certain area, and we don't have to reinvent the wheel every time we have a case come up. We have to look up, and a lot of legal work is looking up those cases to see what they have said about these various things and following those precedents, and that's what the common law is about.
and I think it would be well to clarify, based again on the remarks that Justice Cooper made about the common law. Actually, when the judges, they may change it a bit, but actually they're interpreting the common law as it originated in England and then was brought to Virginia and then to Kentucky. So again, it is more a matter of interpretation than creating the law.
It's kind of interesting. Justice Brennan, who passed away just this year and had served on the Supreme Court for over 30 years, had one view of how to interpret the Constitution, and then some of the other members of the court, Justice Scalia comes to mind on the United States Supreme Court, has a completely different view. Justice Scalia tries to interpret the United States Constitution the way the framers of the Constitution intended for it to be interpreted when they drafted it back in 1787. Justice Brennan took the view that the Constitution had to be interpreted according to present-day facts and actualities, and that since 1997 is a little different than the way things were in 1787, that we had to interpret it to adjust to today's society. And so you do have different divergent views among judges on how to go about interpreting the Constitution and the common law and statutes.
But basically you're interpreting what is written in the Constitution.
That's correct.
And basically, in so doing, it's not a matter of a judge making a law as it is a judge interpreting the law.
That's correct.
That's what we like to say.
Sometimes in my dissenting opinions, I accuse my colleagues of trying to make law, but we hope that they're not.
I'd better not comment on that. I'd best remain quiet about that one.
Now, I thought we had decided before we started that you had reached the age and status in your career where you could say anything you wanted to anybody about anything.
Well, usually I do, and I think I think the judge across from me there will
attest to that.
Will attest to that. Yes. So far, we've talked about judges and their functions mainly. Let's talk a little bit about lawyers. How did they come into being, and insofar as your conception of them are concerned, Justice, how did the lawyers evolve?
Well, I know we would all like to think that the whole legal system could operate like people's court, and that everybody could just walk into court and present the judge with their problems, and he would go back in the back room and take a 15-minute recess and come back out with his decision. But the fact of the matter is that most of the questions that are presented in circuit court and a lot of the questions that are presented in district court are very, very complicated issues. Average layman would not know how to argue about an interpretation of the Constitution. The average layman would not know how to argue about the proper interpretation of a statute. And even in the early days, there developed what we call advocates, that people who would study the law and read the common law in the books, that had access to the books, and would go to court on behalf of someone who was accused of a crime or who had a claim against somebody else and assist them in making the presentation of their claim. And that evolved into the legal profession. And now, of course, I mean, even into this century, we had lawyers, including one Supreme Court Justice, Robert Jackson, who presided over the Nuremberg trials, who did not go to law school. He read the law. But now, all lawyers are required to attend and graduate from an accredited law school where they study the law so that they can better advocate the positions of their clients. But that's my view on how the legal profession evolved from just a learned citizen, if you would, who happened to have studied the law and could make a presentation on behalf of somebody, all the way up to now, today, where we have legally educated lawyers.
You remember that example in law school where Patrick Henry petitioned to be admitted to the Bar of Virginia, and I don't know who he was reading the law with, but he said, "I've been reading the law for 6 weeks and I promised to continue reading the law," and he was admitted to the Bar of Virginia and was from all reports, a very good lawyer. But that's how they did it at that time. And I don't know, I know probably in your experience, Uhel, that you know some folks that probably read the law and got their law license that way. I'm not sure that I know any, but I can't think of any.
Well, you know, we talk about reading the law, and we also had, we know what that means, but for laypersons, I think that's more of an apprenticeship type education than going to a school. I don't mean that somebody could just pick up a law book and start reading. When we talk about reading the law, it was somebody who actually apprenticed under a trained lawyer, much as a
sort of a mentor type situation.
Correct. Yeah.
Teacher.
Came up through and under the tutelage of a lawyer.
Correct.
Did you get your law degree then?
Yes,
I was going to ask him. He was asking us those questions about the Magna Carta, and I was going to say that he's the only one old enough to remember the Magna Carta.
For your information, I have a law degree.
I know, and you were at Nuremberg too. Cooper slipped that in there. I knew that too.
So, in a sense, I've been through the mill. The public generally thinks that a lawyer will do anything to protect his client or to win a case. Judge Dickinson, what is the function of a lawyer insofar as his relationship with his client is, and at the same time the court? Incidentally, is a lawyer an officer of the court or is he not?
The lawyer is very definitely an officer of the court, and there are certain obligations that devolve upon him by being an officer of the court to be candid with the tribunal that he's in front of and those kinds of things. But in the other sense, though, a lawyer owes to his client, number one, confidentiality. You've got to be able to go to your lawyer and be able to say, and it's a very valuable right, what I tell my lawyer is not going to leave this room, so that the lawyer knows what your position is and what he needs to do to represent your case. Now, a lawyer may not participate in fraud. A lawyer may not participate in crime that he knows that a client can't go to him and say, "I'm going to commit this crime," and the lawyer has to keep quiet. There are exceptions to that for fraud and criminal conduct. But honest litigants have to be able to go to their lawyer and know what they tell their lawyer is going to be held confidential. And the lawyer owes a duty to the client to zealously represent that client's interest. And that's what he has to do, or she has to do. You have to draw the line, though, sometimes of what is overzealous representation. But a lawyer owes a duty to a client to represent their interest zealously and to get their case presented in the best possible light that it can be presented in. That's what their duty is.
And if he doesn't, what happens?
Well, he's subject to discipline. It's unethical conduct for a lawyer to ignore his or her client's case to that client's detriment. And it can be unethical, it can be malpractice if they don't do that.
Now, you're using the term unethical. How is it determined whether he has or has not been unethical?
Well, we have rules that we go by. We have ethical code for lawyers and what they can and cannot do in certain cases. What, for instance, represents a conflict of interest in representing one client or another. There are a lot of rules about what a lawyer can and cannot do, just like there are rules about what a judge can and cannot do. And we have rules that we have to go by of what defines what is zealous representation, what we may charge if we are practicing lawyers, what we may charge as fees for our services, and what kind of representation that we have to demonstrate for our clients.
Ultimately, Justice, who determines the ethical code insofar as lawyers generally over the country is concerned, and in particular in Kentucky, and what kind of bar do we have in Kentucky?
Well, I think most people are unaware of the fact that the Supreme Court of Kentucky does more than just decide cases. About 10% of our time is spent dealing with what we call bar discipline matters, and in drafting and approving ethical codes. The Supreme Court of Kentucky is the head of the Bar Association. We call it an integrated bar in Kentucky. Everyone who is licensed to practice law must pass a bar exam administered under the auspices of the Kentucky Supreme Court, and has to pass an ethical evaluation by persons who are appointed by the Kentucky Supreme Court. All cases of disciplinary matters ultimately have to be decided by the Supreme Court of Kentucky, and any disbarments and any reinstatements, all of these matters are handled by the Supreme Court. Quite frankly, I would just assume somebody else would do it because it's a very difficult task. Right at the moment, I'm involved in doing some speaking at what we call the Kentucky Law Update continuing legal education course, and one of the functions that I do in this talk is to go through the bar discipline cases for the last year. I don't mention anybody's names, but I like to go through the litany of the things that they did, and I think it kind of shocks people to find out some of the things that you can be disbarred for, such as failure to properly communicate with your client, failure to properly move the litigation along to a reasonable conclusion. And all these matters initiate with complaints made by clients against lawyers. They go through the Board of Governors of the Bar Association, but ultimately end up in the Supreme Court for a final decision.
And the Board of Governors of the Bar Association are elected by
lawyers. Yeah.
So actually, insofar as the discipline of lawyers are concerned, they discipline themselves subject to the overall jurisdiction of the Supreme Court.
Well, the Board of Governors really functions like a trial court, and they hear the evidence and make a recommendation to the Supreme Court, and then the Supreme Court reviews the evidence and the recommendation and makes the final decision in each case.
Do you happen to have in mind the number of lawyers that was disciplined, we'll say, within the last year?
If you'd asked me yesterday, I would have brought you the number, but I'm going to estimate about 25 to 30.
We have a very similar procedure for judges. there is a disciplinary body called the Judicial Retirement and Removal Commission that hears complaints filed against judges for various types of unethical conduct, and it's composed of other judges and lawyers and lay people. There are 2 lay people on the removal commission, and they hear complaints against judges and make a decision about whether judges have violated the rules that control them. They make the decision themselves, though. It does not go to the Supreme Court except on appeal. The removal commission can remove a judge or give a judge an early retirement or a public reprimand or a private reprimand or
temporary suspension
without pay or with pay or any number of things. And there are, if I remember the statistics correctly, there are about 5 or 6 or 7 serious bar complaints or complaints against judges every year that go to as far as filing formal charges against the judge, and that are heard by the Judicial Removal and Retirement Commission. And that's a large percentage. It's not a large percentage, but it's 5 or 6 or 7 doesn't seem like that big a number, but it is that big a number when you consider there are about, I don't know how many judges in the state, but probably about 220 somewhere along in there.
In that range. You know, the Retirement and Removal Commission, unlike the Board of Governors, is not elected by lawyers. There are representatives that are elected by the district judges, and then another representative of the circuit judges, and another representative from the Court of Appeals. And then the governor appoints, I think, 4 laypersons to also serve on the Retirement and Removal Commission, which is established by the Constitution, by the way. And the reason there's no Supreme Court member is because, once again, all those cases ultimately end up in the Supreme Court for a final decision on the recommendation of the commission.
Basically, in a democracy and in our type of government, who controls ultimately?
Oh, gosh. Well, we have 3 branches of government, and supposedly not one of them controls the other. We all have our functions.
And they are?
And they are, well, the legislature makes the law, and the executive carries out the law, and the judiciary interprets the law.
And the legislature appropriates the money, so they have a little control there too. But everybody has their own function, that they do their own part about making it work.
But basically, going beyond that, who controls?
Well, why don't you tell us? Why don't you tell us?
Well, I guess, are you talking about the citizens can vote somebody out?
Yeah, we're all elected. We're all elected. So if any of us are not doing the job that the citizens want us to do, then we're answerable to them.
So if you get down to final brass tacks, if there's anything wrong, it's up to the public, the citizens, to correct it.
That's right.
Sure.
And their means of doing that is by means of elections for all of these bodies that we're talking about, all 3 branches of government.
Every public official in Kentucky is elected.
Now, we talked about lawyers and their responsibilities. Do lawyers decide any cases? Do they make any law? Do the lawyers make the law or decide cases in your court, Judge Dickinson?
No, I don't. No, they don't. They recommend to me how they would like for me to do that.
But do they make the decision?
No.
Do they award any judgments?
No.
Do they make any verdicts insofar as damages are concerned?
They do not. Not any of those things. They only advocate, and somebody else. It's either the jury or me that makes the decision. And when the jury makes the decision, I'm the one that writes it down and enforces it. But and if they don't want a jury to decide it, then I decide it. But it's either me or the jury. More often than not the jury, but the lawyers don't decide any of that, and they only advocate for the position of their client.
Justice, let's take the Supreme Court and the Court of Appeals, all of the appellate courts. Do the lawyers make any of the decisions of any of those courts?
Of course not. No, the only function that the lawyers have in the appellate courts is to write briefs, to argue their positions, and then, and in not all cases, we have oral arguments in which the lawyers can orally argue in favor of their client, but of course the decisions are made by the judges.
Now, let's get back to the judges for a bit. Somebody is convicted and sentenced to the penitentiary. Now, I realize the judge makes the decision ultimately of the judgment, but it's based on what?
Jury's verdict in a criminal case.
And also the sentence is based on what?
What the jury recommends that they be sentenced to.
Well,
And
the statute, there's a statutory limitation.
There are limits within which
there's a statutory limitation.
Mm-hmm.
The judge doesn't pass that. He is not the one that has established the limits, right?
That's right. That's correct.
The legislature has established that. And the legislature, of course, are supposedly the representatives of the people.
Sure.
Elected by them. Now, once they're convicted and sentenced by the judge in accordance with statutory law, and they serve some time in the pen, and they're paroled, does the judge have anything to do with the paroling?
No,
Justice.
No. We kind of skipped a little step in there. There's a probation
I was going to get to that.
Oh, well, I don't want to take over your lead here, but
I was going to get to that, but let's
go to parole.
Let's talk about parole.
There's a parole board that's appointed by the governor, and everyone who is sentenced has to serve a minimum number of years, and it depends on the nature of the crime, before they become eligible for parole. When they become eligible for parole, then the parole board will examine their record and have a hearing at which victims, by the way, are entitled to speak. And then the parole board decides whether the person would be paroled, and of course that just means released from prison under supervision of a parole officer. I think the present statistics are, correct me if I'm wrong, Benny, is that that on the first eligibility now, the parole board is paroling approximately 16% of those that are when they first become eligible.
I was thinking about 20, but it's low.
It's low. It's low. But at any rate, the parole board is not a function of the courts. It's a function of the executive branch of government.
It's an executive function. The governor appoints the parole board. And, he can intervene, as a matter of fact, and if he wants to, pardon somebody if he wanted to a crime. But that's not a judicial function. Once we lose jurisdiction of the case, when we send them to the Department of Corrections and say, you have got this prisoner now, take care of him for X number of years, then we lose jurisdiction. There is one minor way about shock probation that we still have some jurisdiction for up to 180 days, but by and large, when we give them the Department of Corrections, then it becomes an executive function to take care of them and say how long they're going to stay there.
Well, now, we're back to probation again. Let's talk about probation. You started a moment ago, Justice. Now let's talk about the probation and the difference between parole and probation.
Probation is within the, I don't want to use the word discretion because it's not entirely discretionary. After a jury sentence or a guilty plea, most of these cases are handled by plea agreement, where the Commonwealth's attorney and the defense attorney with the defendant and agreeing and with the approval of the judge will agree on a guilty plea with a recommended sentence. Then it's up to the judge to decide whether the sentence is to be served or whether it is to be probated. Now we have certain statutes that prohibit probation. Class C felony with a firearm, certain sex offenses perpetrated by a person within a certain status to the victim, and a few others. But most of your non-violent crimes are subject to probation, and that is within the discretion of the trial judge, and the statutes in fact require that the trial judge give first consideration to probation, and he can only not probate if he finds that certain facts exist, and the judge, if he is going to not probate, must make a specific finding of fact on the record that a certain fact exists, so that probation would not be appropriate in this case. So the legislature has determined that probation is the preferred sentence, and that penitentiary time comes secondary and only for those who would not be eligible for probation.
That bears repeating. It says that a judge in the circuit court level shall probate a person convicted of a crime unless certain conditions are met. A bad crime, the person is not eligible for parole, the person is in need of correction, the person is likely to offend again. Certain findings that I must make before I can deny somebody probation, but I must consider probation first.
Basically, we're getting into, and have been the last few minutes here, of what I started this discussion with in the beginning, that the judges and the lawyers are given credit for a lot of things that they don't do. And even insofar as your probation is concerned, as both of you have just pointed out, ultimately that is controlled by the legislature in that they tell you what you can probate and what you can't probate, and they also tell you that you should probate except in these certain cases, or shall.
Right.
Yes, sir.
Which is a command of the legislature, and the legislature has enacted the law there, and it is not, again, it is not judge-made law.
That's correct.
As too many people think that you have a lot to do with parole, you have a lot to do with probating, and you don't have anything to do except what the legislature has instructed you to do in either of them.
But I don't want to give the impression that we are some kind of automatons that just have to rubber stamp everything that's alleged. There is a little bit of discretion left there.
Anybody that's ever been in your court, Judge, whether he's a layman or a lawyer, knows better than that. So
there are ways to skin a cat that there are more than one way to skin a cat. And, even though, and I don't ignore the statutes or the advice of the legislature, but a mere finding that the seriousness of this crime depreciates. If I were to probate this person, it would depreciate the seriousness of the crime. I can make that and have made that decision many, many times. That I'm not going to probate you because I think it was a bad crime that you did, and I'm sending you to the penitentiary. But the mandate is there, and if you are honest to your oath of office, it says you shall probate first, unless you make findings of why you're not going to do it.
I remember when I first started as circuit judge back in 1979, we would have these judicial conferences, and corrections department officials would come down and plead with us to please probate more people. We don't have enough beds in our penitentiaries. This was back when we just had LaGrange and Eddyville and one or other one. But anyway, there's a judge not too far from here who's now retired, and they'd send down pie charts, how many sentences you considered and how many were probated and how many were not probated, and his pie chart was full. He never probated anybody. And I think that for instance, I'm out of the business now of probating or not probating, but it was a rare case if I ever probated anybody that committed a sexual offense against a child. I think every judge has his own feelings about different kinds of crimes, and it's pretty easy for me to say, if I think a crime is particularly heinous, even though it was probatable, all I had to find was that probation would depreciate the seriousness of the offense. Well, who decides that? The judge decides that. And so that's how I could get around the shall probate. If I thought the offense was that heinous, then but I'd have to make that finding on the record before I could probate. But judges still have a lot of discretion in that regard.
Oh, there's no doubt about that, but still, the basis of the discretion is still enacted by the legislature.
Still have to follow the statute. That's correct.
That's right.
Let me say something else, Uhel, about that, because that seems to be one of the most troublesome spots with lay people about judges sentencing people and probating people and people being paroled from the penitentiary by the executive branch. The United States used to be number 3 in the world for the number of people that we had in the penitentiary per capita of our population. We only were behind Russia and South Africa. Now we're number 1. We have more people in the penitentiary in this country than any other country in the world per capita. Nobody gets close to us, not even China.
It's expensive, too.
Very expensive. So when people are, my point is, when people are complaining that criminals are walking the streets and nobody's going to penitentiary, more people are going to penitentiary in this country than anywhere else in the world by a long shot.
But the other side of that coin is, and they're out there too, because I hear of it and I read about it, there's other people that are blaming you for having that many people in the penitentiary.
Oh, yes.
And got them overcrowded. And again, it's a matter of the public not knowing the basis of what they're talking about.
Well, here's the theory that I always followed. Back in the early days of my career, when we didn't have as much penitentiary space as we have now, I didn't pay any attention to how many beds there were in the penitentiary. If I thought somebody needed to go to prison, I sent him, and I let the corrections department worry about where they put him. If they didn't have a place to put him, then they were going to have to build some more penitentiaries. But you can't say, you can't get into the habit of saying, well, I'm going to probate this guy because if I send him to the penitentiary, they'll have to release somebody who's worse. And I didn't think that was my function. My function was to decide what was the appropriate penalty, and it was their function to decide how to impose it. You agree with that, Benny?
Oh, yeah, absolutely agree with that. You just can't get into those kinds of... I don't run the Department of Corrections, and I don't parole people, and when I send them there, they find a bed or they do something else. That's their problem. That's not mine.
Now, another thing that I think the judges are sometimes accused of, and I don't hear this as much as I used to, but I still hear it.
Oh, you hear a lot, don't you?
Yes, I do. I've been around a long time. I hear of rigging the juries. And of course, I think that possibly that was done sometime years ago.
Well, there's a case out in McGoffin County. I'm not sure whether it's gone to trial. A part of it has. I don't know what the outcome was, but there was a sheriff and a juror and a circuit clerk that were indicted for that offense, and that's the first time that I'd heard of anything like that in years.
But the judge had nothing to do with that there.
No.
But I think it used to be, of course, and there's still people that, even middle-aged, after all, when you started practicing law, you still had jury commissioners. And it was sort of, it was a system whereby the circuit judge, in drawing names and so forth, could draw one and read another. And I know of some judges that were accused of doing that. I don't say that they did or didn't. I just know someone accused of that some years ago when I first started practicing law. But now you haven't got that system. Suppose you tell us where the juries, who selects the people that go in the jury wheel now, Judge?
A very impersonal big computer in Frankfurt does that, and it's chosen from a combined list of those people in the county who are registered voters and those people in the county who are licensed drivers. And if our clerk here, if Ms. Botts wants, I tell her that I need so many jurors, she'll write to Frankfurt and say, have the computer spit out randomly the names of 1,000 people in Barron County, and we'll start with number 1 and summons that person in and go down and get as many as we need. But that's how we pick the jury now. The commissioners picked people by name. That is, the commissioners didn't let people serve on the jury unless they knew them and that they were good, people of good reputation. And
which is only natural.
yes, yeah, and but that's not the best way to do it. You had good jurors then, but you did not have juries who were a cross section of the community. If they didn't live in a neighborhood, a poverty neighborhood, where the example that I always give, that they didn't know that when people got in trouble that they went out in the street and had a fight about it, and a lot of us didn't grow up in a neighborhood like that. When you heard a case like that, you couldn't identify with that in any way. Well, if you had some of the jurors from that section of the community, they might say, well, that wasn't any big deal. They were just settling their disputes. But we have a very much better cross-section of jurors from the community now, plus we have a lot of young people on the jury, which is really good. Jury commissioner system, the jury commissioners were usually older men who didn't know that many young people. There were hardly ever any young people on the jury. Now I have a lot of young people that sit on the jury, and they make excellent jurors. Some people say the system is not as good because you can't predict what these folks are going to do, but I don't think that the jury system was ever designed to be predicted about what they were going to do. I think we have a very good jury system here. I'm very proud of it.
The first woman to serve on a jury, insofar as I know, in Barron County was in 1951.
Is that right?
When I first started practicing law, you didn't have anything but men on the jury. Judge Frank Jones, this judicial district was created, and he was appointed as judge, and he instructed the jury commissioners to put women in the jury wheel. And it was after he did that that women started appearing on juries. They make good jurors. I like them.
Sure. And another thing that you might bring up about the jury system is that no one is automatically excluded from jury service. Not anybody. Not even judges. I remember when Judge
lawyers.
Or lawyers. Actually, absolutely true. I remember when Judge Ryherd was circuit judge, that my name was drawn while I was district judge, and I went upstairs and served on the circuit court jury. I never was selected by any attorneys.
I bet a lot of lawyers selected you.
Yeah, right. But I've had a lot of lawyers, a lot of doctors, other folks that traditionally school teachers. I consider my summer months, if you want to try a jury to try a case to a jury of school teachers, wait till about June or July, because most of the teachers don't want to serve during the school year, and I say that's fine. Come in June when you're out of school. And we have a lot of teachers and bus drivers and school personnel on the jury during the summertime. But no one is automatically excluded from jury service anymore. Used to be a lot.
I was called for jury service under Judge Walden, and much to my surprise was accepted in a criminal case.
Well, would you like to tell us whether you found him guilty or acquitted him?
Well, I don't mind telling you what happened. It won't take too long, but we went in the jury room, and the jury...
Now we're going to find out who's turning all these criminals loose. It's the jury.
The jurors turned around to me and asked me what they should do, whether I thought the man was guilty or innocent, and I quickly responded that I'm not going to make any statement about what I think until the rest of you have had your say, and then we will discuss it. But right now I haven't got anything to say. And with that, there's one of the men on the jury spoke up, and he said that should turn the man loose, that he knew that he had a family and so forth, and if he was convicted, then who was going to take care of the family? And he was arguing that along that line, and all of a sudden one of the women on the jury reminded him that we had been instructed to follow the judge's instructions, and told him flat out that he was not following the instructions and trying to decide the case otherwise. And then she took over and got into talking about the evidence and so forth, and got others involved in it. And again, I kept my mouth shut until they all had their say, and it was obvious.
You took it over.
It was no, I didn't. It was obvious that they thought the man was guilty, and I did too, and I agreed with them, and we found him guilty. And that lady that made the original man shut up was the one that delivered the verdict. So, and I was quite impressed with the jury. I'll admit
I
that.
have always been impressed with the jury, and I guess I've tried 17 or 1,800 jury trials, and I guess in all of that time, once or twice, I have really been surprised about what the jury did. And I have the authority in those cases to set it aside and start all over again. And I did it in both of those cases, but never in any others. That's the only time that I've ever done that. That I just couldn't fathom how the jury listened to the evidence that they heard in those two cases and reached the decision that they did. So I set them aside.
Well,
and did it again.
you're talking about civil cases, because
Sure.
a criminal case, once
Sure.
the jury
Civil
acquits,
cases is all we're talking about.
yeah, once the jury acquits in a criminal case, it's double jeopardy.
That's it.
Well, I have always, if given, with rare exceptions, if given the opportunity to decide whether I want a jury trial or I want a trial by the judge, I'll go with the jury.
I think that's good advice for any attorneys.
It's been several times that I had criminal defendants that wanted to waive a jury trial and have a judge to try his case, and I just absolutely told him, I said, you are crazy.
That's
I
a
said,
mistake.
a judge with 17 years experience has seen too many of these cases, and I said,
Heard too many stories.
heard too many stories, and is much less likely to acquit you than a jury.
Let's talk a little bit about sizes of verdicts. The criticism that I hear and read is that the judges should do more about curtailing judgments, and I think the average citizen is unaware that in Kentucky the judge does not have the power of remitter. The federal judges do, and they see in the paper where a federal judge has remitted the
Food Line case.
Food Line case. Suppose you explain, Justice, what I mean when I'm talking about a remitter.
Well, in the Food Line case, that was where I believe it was ABC put some, got some employees or fake employees to go into the food line and expose some of their activities. I saw the show and I couldn't remember exactly what it was. But at any rate, Food Line sued ABC for damages, claiming they'd been defrauded by having these pseudo-employees planted inside their store. And the jury found a very small amount of compensatory damages, that was the actual damages, but they found a tremendous amount of punitive damages to punish the television network for engaging in this kind of activity. And I don't remember the exact figure, but $8 or $10 million comes to mind. It was a very large punitive damage verdict. The federal judge, just within the last 2 or 3 weeks, reduced the punitive damage award to $350,000. That's what we call remitter. In Kentucky, the judge does not have the authority to reduce an award. What the judge can do, if he feels that the award is so large that it shocks the judge, makes him blush, I think is the way the old judges used to say, then he sets aside the whole case and you have a new trial from the beginning. But that rarely occurs. And I'm going to tell you something, we rarely have those kind of verdicts in Kentucky. There are occasional, when you see a huge damage verdict in Kentucky, you usually see catastrophic injuries. Very seldom do you see these huge verdicts for minor injuries, and just very rare.
You know, the one that the people always talk about, other than the O.J. Simpson trial, which I wish would have never have happened, but I remember I started counting one time, and the O.J. Simpson trial was mentioned by attorneys in either closing or opening argument something like 44 straight times in jury trials that I was having. But the ones that you hear people talk about the most often is that McDonald's case of the lady burning herself with the coffee. Now, I won't defend that verdict. That was a lot of money for that. But there are two sides to that story. Number one is they did not get all that money. It was remitted on appeal. But the other is that the plaintiff in that case proved, and I'm making these figures up because I don't remember the exact thing, but the plaintiff proved that the coffee was many, many degrees hotter than it needed to be drunk. And they had done some kind of study that it stayed hotter longer if they had it 190 degrees. But in addition to that, they knew that if it got on people, it burned them. They not only knew that, but this had happened 300 or 400 or 500 times before, that customers in McDonald's had been burned, and nothing had happened. Well, when they, and the article that I read about that with this $3 million verdict was the jury arrived at that because that's the profit that McDonald's made off of selling coffee in one day. And that's where they came up with that figure. Well, $3 million for a lady burning her lap with hot coffee on first blush seems way too much, and I wouldn't defend that either. But there are two sides to that story, and that they wanted to let McDonald's know, quit serving super hot coffee. And I think they got the word on that, you know. But that doesn't happen in Kentucky. All of the jury cases that I've seen in Barron County, and I believe we're very, very conservative down here in jury verdicts. I've never seen one that I thought was very much out of line.
And I think the point that you're probably trying to make here is that it's not the judges who decide how much money that the plaintiffs are going to get, it's the jury. And that's the whole purpose of the jury, you see. And I have no quarrel with that. That's why we have jurors. And if they, as the citizens of a community, have viewed the evidence and have found that the plaintiff is entitled to X number of dollars, and if it is not just totally out of the range of reality, then that's what the jury system's all about. And I always tell people, if you didn't want the jury verdict, you could have settled. You know, you didn't have to have a jury trial.
Your experience, Bill, and yours too, Uhel, that jury verdicts in this area are very reasonable. That juries are very conscientious about their duties, and that they really go back to the jury room and analyze the case and try to do the exact best job that they can do under the circumstances. That's been my experience nearly every time.
I agree with you, but again, ultimately, it is the jury that makes the decision. The judge doesn't make the decision. The lawyer doesn't make the decision. The lawyers don't make the decision. And all of this media talk that we have about the big verdicts are the responsibility of the lawyers, and the responsibility is in some instances of the court system and so forth. It's not their responsibility. If the public wants it changed, and I hope they don't want the jury system changed or the court system as we have it today, but if they want it changed, they got to elect people to do it. Unless the change violates the two constitutions, and actually, insofar as the constitutions are concerned, they can be amended also by the public or by the legislatures of the states. In the instance of the federal constitution, that can be either way there. And the state
it's a good
constitution,
system. We don't want to tamper with it too much.
I agree with you 100%, but I hope the people realize that what is happening is not the responsibility of the judges or the lawyers, and that they are getting a lot of abuse that they don't deserve. Our time's up. I appreciate each one of you being here.
Glad to do it.
Thank you very much.
Thank you.
Thank you.